In Jacobs Industrial and International Brotherhood of Electrical Workers, Local 353, Mr. Digg, the griever, was an electrician working for Jacobs Industries, the company. The griever's employment with Jacobs was suspended when he refused to undergo post-incident breathalyzer alcohol test and a urine drug test. His employer said he could return if he underwent this drug and alcohol test and was cleared to return. The union challenged Jacobs' drug and alcohol testing policy and whether it was reasonable to require the griever to undergo such tests given the facts of this specific incident. The union argues that the requirement to undergo a drug and alcohol test in the circumstances of this specific case violates the collective agreement, the griever's privacy rights, and applicable human rights legislation. Their grievance concerns the application of the company's policy to these circumstances only, and not a challenge of the policy itself. The company bases their argument on their own drug and alcohol policy. The policy provides for mandatory post-incident testing if external factors have been eliminated as a possible cause of the incident. Since drugs and alcohol could not be ruled out as a contributing factor of this incident in this case, and because the circumstances of the accident were not outside human control according to Mr. Brown, the company requested the griever to submit a drug and alcohol test. The arbitrator upheld Mr. Digg's grievance, concluding his privacy rights take precedent over Mr. Brown's desire to positively rule out the possibility of drugs or alcohol being a factor. The subsequent union grievance concerning the company's policy to require post-incident testing did not result in any finding of defect in the policy as a whole by the arbitrator. Therefore, the grievance is upheld only to the extent that it deals with the particular circumstances of this case. The arbitrator decided this way in accordance with the 3 elements necessary to justify post-incident testing as described in Weyerhaeuser Co. and CEP Local 447. The elements include the threshold level of the incident, the degree of inquiry necessary before the decision is made, and that there must be a link between the incident and the employee's situation to justify testing. The first and third elements were not satisfied, as the damage was not significant and the accident was minor. Additionally, the griever did not have one indication of impairment during a half-hour investigation meeting. After the griever refused the test, the 4 investigators made no provision for him to be taken home, which is inconsistent with the possibility that he was impaired. This case will be used as precedent for arbitrators when assessing the reasonableness of post-incident drug and alcohol testing in the workplace. However, arbitrators must use caution when using this case in their own decision. Although the grievance was upheld, the arbitrator considered this to be a borderline case where it was appropriate to consider the overall context in addition to the particulars of the accident. Therefore, HR managers must note from the ruling that it should only be applied and used as precedent in similar fact cases where the employee, like Mr. Digg, shows no physical signs of impairment, has no history of drug or alcohol abuse, no disciplinary record, no history of causing accidents, and there is no significant harm done.